Welcome to the One Chancery Lane, usually Thursday webinar. We're having it on a Friday this week for a bit of variety and because of my availability and Richard's availability. So we're very pleased that so many of you can still join us. We're talking today about managing occupational stress claims. As we said in the publicity material, it's a practical guide. We're going to focus primarily on the legal principles and incorporate some practical tips along the way. We'll talk a little bit about whether or not the landscape of occupational stress claims is likely to change with everything that's been happening over the last year with the pandemic. We have a chat function, which whichever one of us isn't speaking, we can try and deal with. Richard has the joy of being my fabulous assistant today in terms of moving the slides along. So it may be more than I can reasonably expect of him to ask him to be answering questions as well as moving the slides forward while I'm speaking. So I may try and do some catch up when he's doing his section because I'm going to speak first and then Richard is going to follow. There's some familiar names on the participant list, but there's also lots of names that are new to me. Just to introduce us, my name's Laura Johnson. I am a barrister at One Chancery Lane, called in 2001. I do a range of work, part of which is personal injury, and a fair proportion of my personal injury work is involved with occupational stress, bullying and harassment cases. Richard is somewhat more junior than me, as you can tell from his more youthful and less careworn expression. And he is building his practice in our core practice areas, including personal injury work and this sort of work. So to get started, Richard, we can move on to the first slide, please. That'd be great. So, understanding occupational stress claims. Occupational stress claims, in my experience, speaking to the people that instruct me and the people that I give these sorts of talks to, are quite marmite. Some people absolutely hate dealing with them. Some really enjoy dealing with them. There aren't that many people that fall in the middle. Those that don't like them, it's often because they feel they can feel very factually dense. There are a lot of issues flying around in occupational stress cases, and they can be overwhelming to get to grips with as a result. I think it's fair to say that occupational stress claims can be difficult for claimants to win. I say that as somebody who acts on both sides, although I do willingly admit that probably more of my work is defendant work than claimant by quite a large measure, not for any particular reason, that's just who's been instructing me. But they do involve a number of hurdles for claimants. And my experience of dealing with these cases for a lot of years now is that the key is to have a clear understanding of the issues. And if you understand the issues, that then helps you focus your analysis and marshal all of that evidence and to weed out what is important and what is not. So we're going to cover some law and we're going to cover some of the common scenarios that we see in practice. Next slide, please, Richard. So, starting with the fundamental principles. The fundamental principles can still be found in a Court of Appeal decision in the case of Hatton and Sutherland. It's a case that went to the House of Lords. One of the cases went through to the House of Lords, the case of Barber and Somerset. But the House of Lords largely approved the core principles set out in the Court of Appeal decision by Lady Justice Hale, as she was at the time. I had the good fortune to be working as a judicial assistant to Lord Stone when Barber was heard in the House of Lords, and so was able to sit through all of the legal argument about it. And if you look at the Court of Appeal judgment, and I really do recommend to anybody who practices in this area or who wants to practice in the area to dig into that judgment and become very familiar with it. It sets out this series of 16 principles, not all of which are still good. And what has been said of Hatton, I think this is a very fair summary, is although it's not to be read as though it is a statute, the judgment of Lady Justice Hale in Hatton provides useful signposts for judges faced with the sometimes complex facts of stress at work cases. Now, one of the very interesting questions that we were asked by somebody as they registered for this webinar, Chris Fletcher from BLM, is to what extent are the Hatton principles showing their age in light of the recent spotlight on mental health? And that's a really interesting question. My personal view is that the Hatton principles are still good, but they aren't to be read as statute. They are simply guidance. And perhaps what has changed, what is changing, what is likely to change is how we interpret them as we apply them to the facts of particular cases, and I'll talk more about that as we go along. What does Hatton say? The ordinary principles of employers' liability apply. So there are no special control mechanisms applying to claims for psychiatric or physical illness or injury arising from the stress of doing the work the employee is required to do. So far so simple, but why does this require us to give a talk if there's nothing unusual about it? Well, you have my but there. Next slide, please, Richard. The courts recognise that stress is a subjective concept, the individual's perception that the pressures placed upon him are greater than he may be able to meet. Adverse reactions to stress are equally individual, ranging from minor physical symptoms to major mental illness. Next slide, please. So these claims do require particular care and determination because they give rise to some difficult issues of foreseeability and causation, and we would add identifying a relevant breach of duty. As Lord Justice Simon Brown pithily put it in Garrett's case at paragraph 63, many, alas, suffer breakdowns and depressive illnesses, and a significant proportion could doubtless ascribe some at least of their problems to the strains and stresses of their work situation, be it simply overworking, the tensions of difficult relationships, career prospect worries, fears or feelings of discrimination or harassment, to take just some examples, unless, however, there was a real risk of breakdown which the claimant's employers ought reasonably to have foreseen and which they ought properly to have averted, there can be no liability. Next slide, please. So if you take nothing more away from this talk today than this, please let me reinforce to you the key point, which is this. Developing a psychiatric illness that is connected with work is not sufficient on its own for a successful claim for occupational stress. And if I see any sort of recurrent problem in the claims that I have crossing my desk, it's that there doesn't always seem to be an appreciation of those that are bringing claims that simply having a psychiatric illness that is connected with your work is not enough to succeed in the case. So what is needed? 1, there must be a real risk of breakdown. 2, that the employer ought reasonably to have foreseen. And 3, which they ought properly to have averted. Somebody has just asked whether you'll be receiving the slides after the talk. Yes, I think the slides will be circulated, and also a link to be able to watch this video and to circulate it on YouTube. Next slide, please, Richard. So today, Richard and I are going to be talking about these topics. Firstly, the threshold test foreseeability. It's going to be me that deals with that. It's very important, and it's the first thing that everybody must think about when you open a new case. And then Richard is going to take over to talk about breach of duty and causation. So starting with foreseeability. Foreseeability is the issue on which many occupational stress claims founder. It is the threshold test, that's the phrase used by Lady Justice Hale. If the claimant cannot establish foreseeability, then the claim will fail. So both parties must keep a laser-like focus on it. And in order to do so, you need to understand what it is. So next slide, foresight of what? It is foreseeable injury. You'll see I put injury in red. You might already have gathered that if I put the parts of my slides in red, it's because they're important. It's foreseeable injury flowing from the employer's breach of duty that gives rise to the liability. It does not follow that because a claimant suffers stress at work and the employer is in some way in breach of duty and allowing that to occur, that the claimant is able to establish a claim in negligence. So these can be difficult concepts to wrap your head around, but essentially what's being distinguished there is one can have a scenario where somebody is overworked, their employer maybe doesn't act as they ought to, as they in managing their employees' workflow or whatever the issue is in the case. But if the employer doesn't and shouldn't have, nothing's happened to put the employer on notice, foreseen that what is happening is making the individual ill, if that individual then has a breakdown and goes off work, that is not enough to establish liability. Next slide, please. So the test of foreseeability is this: whether this kind of harm to this particular employee was reasonably foreseeable. And this has two components. One, an injury to health. And again, I emphasize this to those of you who are new to this area, as distinct from occupational stress. So stress on its own is not enough. And B, which is attributable to stress at work as distinct from other factors. So what are we looking for when you receive the pantechnicon of employment records for an individual and medical records? What are you actually looking for when you're considering this threshold test? Well, in Hatton, Lady Justice Hale identified that a number of factors would be relevant to the question of foreseeability, but in particular, the two things that we're looking at are these. A, the nature and extent of the work being done by the employee, and B, signs from the employee of impending harm to health. So your inquiry needs to take you into two directions. One, what was being asked of the employee at work, and then two, how is the employee reacting to what was being asked of them? Next slide, please. So in terms of the first of those questions, the nature and extent of work, one of the inquiries that the court will look at, and one of the things that you can explore, is whether this claimant, this employee, was under unreasonable pressure. Now, unreasonable pressure on its own isn't going to be enough to establish foreseeability, and this is one of the areas that the Hatton judgment is very interesting to read on, because the courts recognise that people deal with stress in different ways. There are people who thrive on stress and they need the pressure of work to perform at their best, and there are others who are operating in ostensibly low-key jobs who find it very stressful because of things that might not be immediately obvious, so feeling disempowered, disenfranchised, those sorts of things. So it's a complex issue, but one of the things that you will look at is the employee under unreasonable pressure? Now, I think this part of the inquiry is where there will be some relevance of what's happening with COVID and the pandemic, in that I think it is recognised that for many people, their working environment has changed. Some people, their working environment has become objectively more stressful for various reasons, if they're key workers or whatever. For others, that to do particularly with their work environment might have been changed, but stress is going to be greater because of reasons unconnected with work. Are there high levels of sickness absence? So what you might be looking at is what's happening in the claimant's immediate team. The further away from the claimant's immediate team you travel, factually, the less relevant it's going to be. And then this is important, and I have a number of cases where there's been attempts to circumvent this. Hatton says in terms at paragraph 24 that there are no occupations which should be regarded as intrinsically dangerous to mental health. And Hatton looks at the sort of scenario of, for example, road traffic officers dealing with traumatic sights and sounds. And again, the law recognises that some people cope very well with those jobs and some people don't cope with them at all, just as some people cope very well with jobs that don't involve any exposure to something that's traumatic or upsetting, and some people don't cope with those jobs at all. There's one exception to that, the case of Melville and the Home Office, which is worth having a look at if you've got one of these cases. And in that case, the claimant was employed as a prison officer, and his usual duties were to be a prison officer and carry out the usual functions of that role. But part of it involved him having to deal with the bodies of prisoners who had committed suicide. And it was recognised by the Home Office as an employer that this was something that foreseeably could cause harm to somebody's mental health. And as a result, if the individual had to do that task, they were expected to go off and have counselling afterwards. And that process failed in Melbourne, the Home Office. And that was a case where the court said it was so clearly recognised by the employer that the individual could suffer psychiatric harm as a result of this task, that foreseeability didn't have to be established in terms of the individual's reaction to it. It's something of an outlier, I think, Melville, and it's very much a decision on its own facts. But certainly, I think where you have an employer who has employees who are carrying out tasks that are particularly upsetting or traumatic, the court might be more willing to think that that employer should be more alive to signs of psychiatric reaction. But nonetheless, it remains the case, in my view, that the law says that there are no occupations that enable you to bypass the need to establish foreseeability. So that's the nature and the extent of the work. Turning on now to the signs from the employee. This is an important point. Signs of stress are insufficient. We're probably all stressed at the moment. We're probably all showing it at times. Certainly people in our co-working teams are probably showing it. We work in what are, often stressful occupations, even when you're not trying to navigate through a global pandemic. Stress on its own is not enough, because a lot of people are stressed at work and stay stressed at work for long periods of time, but don't ever get psychiatrically unwell. So there's a distinction between signs of stress and signs of impending harm to health. Stress is merely the mechanism which may, but usually does not, lead to damage to health. Next slide, please. So this is a sort of my summary of what may not be enough. It comes with a very heavy caveat that cases are fact specific. And so, please don't take this as being written in stone. You need to look at your own individual facts of your case and ask yourself what the reasonable employer might be expected to take from the signs that the claimant was showing. But on its own, usually, what is not enough? Complaints about workload. Lots of people complain about their workload. Requests for more help with their work. Complaints on their own about interpersonal problems. Mention of the word stress. Disciplinary procedures, even involving an act of unfairness. And I've referenced for you there 2 important cases. YAP in the Foreign and Commonwealth Office and Devon and Bristol County Council. YAP is a case that it's really important for you to become familiar with if you work in this area. It was a case concerning the High Commissioner of, I think, Belize, who was accused of inappropriate behaviour of a sensitive sort, and as a result was pulled from his post without further ado, and then was the subject of disciplinary proceedings that were not conducted fairly. And the court carried the judgment's good because it's got a really useful summary of the cases up to that point in time, but also makes it clear that your ordinary employee, without further signs of impending harm to their health, disciplinary processes, and even those involving an act of unfairness. And so still that individual needs to show that they were showing signs of impending harm to health in order to overcome that threshold question of foreseeability. The next one's an interesting one that I see quite often. In my view, an historic work-related stress absence, after which the claimant has returned to work without any apparent difficulties, is not enough. I quite often see cases where claimants seek to rely upon absences a year earlier or 2 years earlier, and sometimes even longer, where they've been signed off with stress, they've come back to work, they've gone through their phased return, they've been apparently working as normal, and then something's happened and they've gone off again. Now, a historic work-related stress absence could be sufficient if the claimant has continued to complain about problems that would objectively put an employer on notice of impending harm to health, but without that, in my view, it's not enough, usually. Disclosure of previous depression to occupational health, so the fact that the employer knows that somebody's had mental health problems in the past, and the disclosure to the employer of counselling, both those come from the case of Hartman, which is also worth a read, usually on their own, not enough. So what might be enough? It's fact specific, and cases can throw up all sorts of unusual facts. So again, this isn't a comprehensive list, but it's the sort of thing that I commonly see. So a recent sickness absence attributed to work where the claimant has returned to work but hasn't held themselves out as being better. And I can't remember if I referenced this later in the talk, but I think I might do. I think it might be something Richard's going to talk about, but the end of a sick certificate in itself isn't confirmation that somebody's better. It's just confirmation that somebody no longer needs to be signed off from work. So if the individual comes back and they're continuing to show problems and complain about how they're feeling, that is probably sufficient for foreseeability. Assertions at work that work's harming their health, and it doesn't have to be somebody sitting in the meeting saying, my mental health is being harmed here. But complaints of sleeplessness, not eating that are tied to work. Erratic behaviour that is out of the ordinary and in the context of unreasonable work demands. So, for example, tearfulness. I've given you there the case of Hale in South Gloucestershire. But again, it's fact specific. So the counterpoint to Hale is Sayers in Cambridgeshire, which is a case where there had been tearfulness at work, but objectively, the employer wouldn't necessarily have been expected to see that was connected with work, as opposed to other things that were going on in that individual's life. And in terms of relevance of the modern understanding of mental health in the workplace and COVID, this is where I think that the Hatton principles, although expressed in an old-fashioned way in some of them, have the flex to cope with our changes in understanding, because I think probably what we would expect employers now is to be more alive to these signs of impending harm to health. So they still have to be clear and objectively clear signs of impending harm to health. But I think what we might expect of an employer in 2021 is different from what might have been expected from an employer in 1990. So that's where I think that the Hatton principles have the flex to accommodate the developing understanding that we have about mental health issues in the workplace. Next slide, please. So continuing on the signs from the employee, here are some of the nutshells from Lady Justice Hale. Unless he knows of some particular problem or vulnerability, an employer is usually entitled to assume that his employee is up to the normal pressures of the job. It is only if there is something specific about the job or the employee, or the combination of the two, that he has to think harder. Thinking harder doesn't necessarily mean he has to make searching or intrusive inquiries. And generally he is entitled to take what he's told by or on behalf of the employee at face value. So that is where I think that the principles and the exposition of Lady Justice Hale has the ability to accommodate changes in our understanding of mental health in the workplace. Because, as I was saying, what might trigger the requirement on an employer to think harder may be different now from what it was perhaps when I was starting my professional career. Next slide, please. So that finishes my section on signs from the employee. And the next thing that I want to look at is, well, foresight of what? What does that mean? Well, what must be foreseeable is not merely a general risk of psychiatric injury in the long term, but a particular risk of injury in particular circumstances and by a particular mechanism. So this is quite a tough one for claimants, and the case of Pratley in Surrey is worth familiarising yourself with. In that case, the claimant had been complaining about the amount of work she was being given and complaining about the effect that it was having on her, and her employer had promised that they would put in place a new process to help her manage her work that would be implemented when she came back from a period of leave. She came back from her period of leave, the system hadn't been implemented, and she had her psychiatric breakdown and went off sick. And the Court of Appeal said in that case that whilst it might have been foreseeable that if the employer continued to require her to work at the level that she was working for a protracted period of time, she might suffer psychiatric injury in the long term. So she overcame foreseeability to that extent. But what was not foreseeable, according to the Court of Appeal, was that when this cherished work management idea wasn't implemented, that she would have a sudden and significant psychiatric reaction to it. So when you're considering foreseeability, you need to look very carefully at what it was that provoked the claimant to develop their period of psychiatric ill health. And was that thing the same thing that they were complaining about and that the employer might have been on foreseeable notice about previously? So, you know, one often sees cases where there's a whole mixture of things going on at work, allegations of overwork, organisational change, structural change, perhaps a redundancy round, difficulties in peer relationships. And it's not infrequently the case that the thing that the claimant was complaining about in the long term previously in the past is not the thing that actually caused them to suffer their mental health issue in the immediate moment. So you need to look at that very forensically. So last slide on foreseeability, managing the evidence. The devil is in the detail. And believe me, I know the pain that all lawyers feel when dealing with these cases, because they often do generate a huge volume of documents. But there is no substitute, I'm afraid, for having your actual or your computerized highlighter out and post-it notes and going through the papers really, really carefully to pick out all of the nuggets of evidence that are important to the question of foreseeability. You have to look for what is not there as well as what is there. So you need to look at the whole context. You know, there might have been a historic complaint 2 years before the claimant went off, but what's in all the emails for the 2 years after that? The claimant might be saying that they'd had all these dreadful conversations with people, but is that about how awful work was and what a toll it was having? But if you're sitting looking at the 4,000 emails they sent over that time and there's nothing that reflects that contained in it, look for what isn't there as well as for what is. And I say this to lawyers acting on both sides because the forensic exercise is the same, whoever you're acting for. And then have a look to see whether there's a disconnect between the medical records and the employer's disclosure. So sometimes you may have a case where the individual's being quite honest with their GP and turning up to tell the GP how hard they're finding things at work, but they're not saying the same thing to their employer. And the question is, what did the employer know, or what should the employer know in order to trigger that duty to take steps to prevent them suffering from that psychiatric harm? So that ends my section on foreseeability. I'm going to mute myself and hand over to Richard to deal with breach of duty and causation.
Hi everybody, let me just get the slides up. Here we go, breach of duty. So the key point there is that this is not the employment tribunal. So it's not an unfair or constructive dismissal claim with all the associated very particular law. It's not a disability discrimination claim. It's a personal injury claim being brought in the county or high court. So bear that in mind, really sort of conceptually. And that's the key question in the middle there. Whether, having been placed on notice of an impending risk of harm to health in the particular employee, so the foreseeability aspect of it, the employer has taken proper steps to guard against that risk. Now, it's the ordinary, as Laura was saying earlier, it's the ordinary principles of employer liability which apply here. So it's a duty of reasonable care for the employee's safety. You know, obviously with regard to stress and psychiatric injury, but it's that same duty as would apply to physical injury. And as it says at the bottom there, it's all about health and safety. Now, with breach on the common pleadings issues, the central point here is they must be specific on breach. It can't be general, you know, overwork or just generally speaking failed to do this or could have been a bit better. You need to identify at particular times with particular individuals exactly what should have been done. So as Lady Justice Hale said in Hatton, in all cases, it is necessary to identify the steps which the employer both could and should have taken before finding him in breach of his duty of care. Now, with pleadings, as it says there, avoid, well, if you're a claimant litigator, or challenge if you're a defendant litigator, lazy pleadings. As I was saying with claimants, what is the real complaint here? It must be factual and clear. And if you are a defendant litigator and you are responding to a lazy and generic particulars of claim, consider Part 18 requests to really force the claimant to pin his or her colours to the mast, so you know the case that you're responding to. It will certainly make it a lot easier for identifying the relevant parts of the many folders, though which you'll have to read in full anyway. Common issues there, so unparticularised allegations of breach of statutory duty, it's not good enough. Pro forma allegations that do not engage with the facts, so as I was saying before, overwork pleaded, but the case is actually about unfair disciplinary procedures. So if ever there was a type of case for which a pro forma pleading is not appropriate, it is this, because it must be very specific to both the employee and the employer, and it needs to be clear from the pleading that you've identified and focused on what really is the issue here. So for example, don't mention overwork if the case is about the disciplinary procedure. Don't just throw in that casual general allegation, as all too often does happen in personal injury litigation. Avoid that temptation. And also it says they're vague allegations that do not identify people, events or dates. Again, I mean, these are things that should be done with all pleadings, but particularly with stress at work. If for no other reason, just to help the judge with understanding the case, identify the dates and times and the people, what should have happened, and then eventually why. Moving on to the next slide, more guidance from Lady Justice Hale. So this first bullet point here, we see, and this is really just ordinary principles of tort. It's the standard of care and the factors that inform that standard. So it's the duty to take the steps which are reasonable in the circumstances. So reasonable care is the standard, bearing in mind the magnitude of the risk of harm occurring, so the likelihood that the harm will occur, the gravity of the harm which may occur, the costs and practicability of preventing it, and the justifications for running the risk. Again, basic principles of tort, but still important to bear those in mind. Second bullet point there, the size and scope of the employee's operation is relevant. So its resources and the level of demand that it faces. Also, and this is a really important point, to remember the other employees as well. So if the issue is, for example, overwork or interpersonal problems with dealing with a particularly difficult co-worker or manager, essentially anything that, in terms of responding to this particular employee, this claimant's problems, will require a restructuring and a greater level of imposition on other employees, you must bear them in mind as well. You can't, for the sake of responding to the particular employee's problems, then have an unfair distribution of work on the other employees. It says at the bottom there, but take care with resources arguments. Again, that's true of all personal injury litigation. If the business can't operate in such a way that the employees are kept reasonably safe, then the business shouldn't operate. It's not enough just to say, well, you know, we're a small business and we've only got a handful of employees and we're having to fill a very high level of demand at the moment, and it's really important because we're in the early years of the business and we can't turn work down. So it just is what it is, and there's no way of avoiding that our employees are going to be greatly stressed. That isn't good enough, because if you can't keep your employees reasonably safe, then you shouldn't be operating. Moving on, more guidance from Lady Justice Hale. So it's only those steps which are likely to do good, which an employer can reasonably be expected to take. Now, this is going to be very case and claimant specific. So what would have worked in this situation? That's what the employer can be expected to do. but it will be weak if that assertion is coming from is made as a bald assertion just by one of the lawyers involved, for example. So if it's the defendant lawyer saying, well, that wasn't one of the things that the employer was expected to do because it wouldn't have done any good anyway. Really, that's a technical, clinical question. So you're likely to need expert evidence on this, explaining why it wouldn't have made a difference for the employee's psychological state to have done that particular thing. Second bullet point there, if the only reasonable and effective step would have been to dismiss or demote the employee, the employer will not be in breach of duty in allowing a willing employee to continue in the job. Now, this is the general principle. At the absolute extreme, and this was, I'll come on to this, but it was covered in Barber. At the extreme, it may be arguable, but generally speaking, if you have an employee who is struggling and all reasonable steps have been taken, and the only alternative to prevent a breakdown is to dismiss them, but the employee wants to stay, they're willing to stay, generally speaking, an employer can't be blamed for letting them stay. So finally, that in all cases, it is necessary to identify the steps which the employer both could and should have taken before finding him in breach of his duty of care. So this is the same thing that I opened with on breach here, that the allegations must be specific. A claimant must identify the things which the employer both could and should have done. So yes, just to emphasize, need to be really specific on it. Breach of duty, reasonable steps. So these are the things that an employer, generally speaking, again, very fact specific, but generally speaking, an employer can be expected to have done, and where they haven't, that will be suggestive of breach of duty. And again, this isn't a cast iron list of things that absolutely must be done for every employee by every employer, but it's a general list of relevant factors. So there are some obvious but important ones here. So a prompt referral to occupational health, and then following the recommendations as well. Now that's pretty basic, really, that where you have an occupational health department within your organisation, and as a manager, you have an employee coming to you and saying, I'm really struggling. It's pretty basic to then refer them onto the occupational health department as why they're there. So you should expect to see that. Addressing workload complaints. Again, pretty basic. If there are emails from an employee saying, I'm having problems with X, Y, and Z part of my workload, that should be addressed by a manager, even if it is to say, for whatever reason, right now it can't be done, but we'll try and do this, this, and this instead. But it must be responded to. It can't just be ignored. Taking steps to deal with interpersonal problems. So where an employee is having particular problems with a co-worker or manager and it's really causing them stress, again, trying to do something about that. There's nothing really complicated about these points here. It's really just basic human cooperation, if anything else. It's just listening to the person that is approaching you. We see here as well some other things that I'll come on to them in a moment. So sort of stress risk assessment and counselling services, general management support. Those are examples of more general things. So having a counselling service and doing your risk assessments are not necessarily employee specific, but they're general structures that most employers can be expected to have in place. Alongside that general backdrop, you then have to look for the specific things that the employer has done with this employee. So depending on which side of the fence you fall on, claimant or defendant, you're looking for evidence of the employer actually listening to this claimant to their particular complaints and being responsive, because it's not enough just to have in place the general things. There also needs to be attention to the particular employee. So, for example, with an EPA or counselling service, Indoor and Intel, for example, the point was emphasised, it's been made in earlier authorities, but it was emphasised in that case that providing a counselling service is not a panacea to answer all occupational stress problems. It's not enough just to say, well, I know that my employees are wildly overworked, but we've got this token counselling service in place, so that's good enough, and I referred him or her to it. It's a good thing to have, but not enough. So Indoor, for example, the employer was found in breach in that case, notwithstanding the provision of a counselling service, because the employee there needed their workload reduced. So that it's not enough just to treat the symptom as such and say, oh, well, whatever is causing your stress, here, go and speak to someone about the stress. You also need, as an employer, to look at what is causing it. How can we address that? So where it is the fact that the employee is overworked, you would be looking as a litigator for, well, what did they do about the overwork? Not about just the stress assessment, not about the counselling, not about general help measures. What did they do about the problem? And I think that's a really important, as an example of how you need to approach these cases precisely, to look at what was the problem here and what was done about that. That's the main sort of purview. So with stress risk assessments there, generally speaking, most employers, yes, will be required to do, as part of their general risk assessment obligations, will be required to do a general stress risk assessment, but it must be shown, and this was covered in Easton against B&Q, and then also built upon in Bailey and Devon, that if the assessment had been done, it would have shown a general risk of psychiatric injury to the claimant or the claimant's small sort of category of employees. So in Easton, it was held that, well, there wasn't the general assessment done, but if there had been, this particular employee wouldn't have been identified as someone at any real risk of psychiatric harm because he was a manager in a shop. So again, with the general measures like risk assessments, you need to be thinking, okay, yes, they need to do one, but had they done one, what would it have shown? And then if it had, for example, shown that this was an employee or someone within a category of employees that's at a general risk of psychiatric harm, what then should have been done? So even with the general measures, always thinking, how can I make this more specific in terms of the allegations? It says their management support. Again, I mean, pretty basic, that if an employee is holding themselves out as having problems, that their managers should be trying their best to support them. Just basic stuff. Finally, pursuing disciplinary action with reasonable expedition. This is Piepenbrock against LSE. I'm very nervous to describe this case because it's Laura's case, and I'm worried about describing it the wrong way, so I'm going to keep it very, very brief. It's quite a complicated case, and I'm not going to be able to deal with all of the issues, but broadly speaking, and I'll be corrected if I'm wrong, the claimant was an academic at a uni, and he had a complaint made against him of sexual impropriety by a graduate teaching assistant who he'd been working quite closely with, and they'd gone on a trip abroad, and it had all sort of come to a head there. Now, he sued the university because of the uni's handling of the complaint. Now, the court found that the defendant had failed to proceed with the complaint sufficiently promptly, but ultimately the claim failed because of lack of foreseeability. So where there are complaints made against employees, they need to be carried out and dealt with reasonably quickly, or at least without undue delay, because even where the complaint is well-founded, and even where that employee may have done something wrong, I'm speaking generally here, not to the particular facts of Piepenbrock, but just generally speaking, notwithstanding that there may be good grounds for the complaint, it's still obviously a very stressful thing to undergo. So the employer needs to deal with that reasonably promptly. So it can go from being the employer almost attacking, for lack of a better word, the employee for having done something wrong and opening, or there having been a complaint made against them, to suddenly almost role reverse, and the employee saying to the employer, well, you didn't deal with this quickly enough. So, there's now a claim arising out of that. Moving on, I'll be as quick as I can. I don't have a great deal more to get through. So breach of duty, unreasonable steps. So these are things that, generally speaking, an employer won't be expected to do. So as we were saying before, dismissal, where you have an employee who's willing to carry on working there, notwithstanding stress they're experiencing, it, generally speaking, isn't incumbent on an employer to dismiss them if that's the only alternative. There may be an exception to this in the absolute extreme, and that was commented on by Lord Walker and Barber, but I think that will be only the most extreme situations. Generally speaking, employers can't be expected to dismiss their employees. There can be no claim arising out of the manner of dismissal, even wrongful dismissal, and there's a pretty simple reason for this, and it was explained by the House of Lords in Johnson. It's a claim can't be made in the county court because Parliament has already provided the right to claim for unfair dismissal in the employment tribunal. So just, as a basic point, the claim can't be made. So moving on, abandoning legitimate performance management. So where an employer is wanting to perhaps change their business slightly and they're wanting to monitor and manage the, either through their own volition, their own decision to do this, or because it's being imposed by an external body, where the employer is wanting to do that, simply because that may cause, one employee or one or more employees some stress, it's not a reason in and of itself to abandon legitimate plans for changing that. For example, in Vahidi against Fairstead School, that case involved a reception teacher, and it was a school who was responding to government changes, which resulted in changes to the school's teaching methods. Essentially, it was a nationwide phase of modernising teaching. It was around the turn of the century, with greater inspection and marking systems and points for monitoring the school's performance. So that had to change the way that the school provided teaching. The claimant was unable to cope with those changes, but nonetheless, the school wasn't found to be in breach because it persisted with the plans to change. Similarly, organisational change. There's a case there, Fumini. So the claimant in that case was the head of a department at a uni. There was internal reorganisation, meaning that the department was going to lose its autonomous status. The claimant was strongly opposed to that, and it was his opposition to the change which caused stress. But the court found that it wasn't unreasonable to persist with the change, because businesses have to be able to change organisationally. They have to be able to respond to changing environments or to improve their methods. They also, as in Vahidi, they have to be able to change the way that they manage and monitor performance. Finally, the last bullet point, steps that place an unreasonable burden on other members of staff. So as we were saying before, when you're considering measures that could have been taken to lessen the burden on the particular employee, you also still need to be thinking, but would that have imposed an unreasonable burden on others? And an employer can't be expected to do that. They can't be expected to spare one employee's health for the sake of, can't be expected to harm other employees' health for the sake of just sparing the one employee in the case. That concludes me on breach of duty then. Very quickly on causation, which for some reason is now coming out bullet point by bullet point. It says that as crucial as foreseeability, This is a critical point here. We see some of Laura's writing in red there. When Laura was mentioning that before, I had flashbacks to being a pupil and handing work over to Laura and getting it back absolutely covered in red pen. So yeah, this is a critical point. The claimant must show that the breach of duty, the particular breach which has been alleged, has caused or materially contributed to the harm. And this is key. It is not enough to show that occupational stress caused the harm. So you can't just say, here's the claimant, they suffered a psychiatric injury, that injury was caused by stress at work, and perhaps the employer was generally, a bit rubbish, could have done better, therefore the claim must succeed. No, that's not enough. The claimant must have identified the specific breach of duty and be able to say it was this breach, notwithstanding a number of other potential problems. It was this breach which caused or contributed to materially the harm. It's really, really important to bear that in mind. And we see here another quote from Hatton, that where there are several different possible causes, as will often be the case with stress-related illness of any kind, the claimant may have difficulty proving that the employer's fault was one of them. And that's because there are many different stressors in life. There are lots of things that may have been affecting that particular claimant at that particular time. There may have been other things even within their working life that was causing the stress, but they need to show that it was the particular breach which caused it. Moving on, expert evidence is key. That's because it will take the expert, it will take the specialist to be able to say whether and why it was the particular breach which caused the injury. And so the expert must be instructed to consider the case in appropriate forensic detail and must closely consider the particular allegations of breach of duty, not just whether work generally was a cause. So it's not enough to have a psychiatric expert saying, oh yes, this is a claimant that suffered a psychiatric injury and it's related to work, or it was, generally speaking, caused by work, or even to say, oh well yes, overwork was a cause of it, and that's that. They need to go through the case in real detail and also very closely follow the particular allegations of breach. So that's really a matter for instructing the expert, make sure that they are approaching it very, very carefully. Apportionment there, I think I'm struggling a little for time. Yeah, I'm not going to go into great depth on apportionment. But the case here, BAE Systems against Konzak, approved some obiter comments that were made in Barber. Essentially, where there are multiple extrinsic causes of psychiatric injury, the court should make an attempt to sensibly apportion them. So how much of the claimant's eventual psychiatric injury can be attributed to the employer's breach of duty? However, it may be that the injury is indivisible, in which case apportionment would be wrong, but that's something that's going to need expert evidence. Finally, a pre-existing disorder or vulnerability. Broadly speaking, you need to consider, or the expert needs to be instructed to consider whether there would have been a breakdown in any event. So some conclusions. I think I'll hand this over to Laura then to end with, if that's okay.
Because I've been back onto the screen.
Yeah, I'm taking my cue there from the fact that you've entered again. Thank you very much, everyone, and have a great rest of your day and weekend. Thanks, bye.
Thank you, Richard. Just as a couple of closing remarks, because we are coming to the end of the session, which is scheduled for an hour, and I know you'll have busy things to get on with. Conclusions are quite straightforward. Get stuck into the detail. Keep these legal principles very firmly in mind. And if you keep them very firmly in mind, you can't go too far wrong with these cases. But failing to keep an eye on essentially the ladder of tort that you have to follow, of foreseeability, breach of duty and causation is where one sees these cases going awry. We've probably hammered it home enough already, but stress or illness caused by work is not enough. What you're looking for is a real risk of breakdown that the employer ought reasonably to have foreseen, and then the steps that you're concerned with is what should the employer have reasonably done to avert that breakdown that they should reasonably have foreseen. And then the very difficult one that we all grapple with, instruct the right expert and instruct them to do their job properly. Occupational stress cases, more than anything, are cases where you really, really need to make sure that your expert is doing a proper job. And by that, I don't mean trying to change their professional opinion. What I mean is making sure that they have engaged properly with the pleadings. So what are you saying on behalf of the claimant, or if you're for the defendant, what is the claimant saying? Amounted to foreseeability, would have averted the problem arising, and to make sure that they've done that incredibly tedious task of going through all the documents properly. I've seen some hands coming up. We can't let you speak, I'm afraid, because of the settings of it. What I can say, though, is we're very, very happy to answer any questions you have. If Richard moves on one more slide, you can see our email addresses. You can also contact us via the clerk's email at 1 Chancery Lane. If you want to email us any questions, then please do. We'll come back to you after today's discussion. That's not a problem at all. We hope that it's been a helpful either introduction if you're new to this area, very interesting area of work, or if you're already experienced with it, we hope it's been a useful refresher. It's been very nice to speak to you all today, and there will be an email, I think, circulating the YouTube link, and also I think Emma, our manager, will be sending round the slides. It often takes a day or so because she'll edit out all of the chit chat at the start of the recording, so that the YouTube just starts at the beginning of the talk. So don't be surprised if it takes a little bit of time for it all to be circulated to you. Thank you very much, and we will say goodbye. Have a good weekend.